Labrīt. Good morning, ladies and gentlemen. I welcome you to University of Latvia and welcome to this small aulā or aulā parvā. This is a really important and magnificent place in university. First of all, this is one of the most splendid places in university, and you can see the architect tried to color the foundation of Rome, city of Rome here. So the most characters of the foundation of Rome is you can see there. And it's also important as in 1919 in this place the University of Latvia actually was founded. So the official ceremony was held here. And today we are actually holding second day of the conference and private law section. So my name is Inga Kačevska and I am assistant professor or docent of University of Latvia Faculty of Law, and I will be chairing this session mostly devoted to international civil procedure law. As you will see, we will cover arbitration, mediation, and also mutual legal assistance treaties. Please notice, first of all, I will speak in English as we have a distinguished guest today, and I will introduce them right before their presentations. You also will have opportunity to give your commentaries or ask the questions to those experts right after all presentations, so at the end of this session. So let's start today's session. And it's a really honor for me to invite as a first speaker very, very prominent arbitration specialist in the world, very well known in the world, and I would say one of the leading arbitration specialists in this planet. This is Domenico Di Petrio, and he is a professor at University of Rome. Also, he is a fellow at University of New York Law School, but also he is very well known as a practitioner, both in commercial arbitration and investment arbitration, and currently he is based at Freshfields Bruckhaus in Deringer. I should add that he is author of this wonderful book, edited by also Emmanuel Gaillard and Domenico. It's about enforcement of arbitration agreements and international arbitral awards. And you can see how used this book is, so it's very valuable. And when architecture created this hall, he compared the Rome and Riga. So we invite you, I don't know whether you will compare Rome with Riga, but we are really looking forward to hear about the new trends and about the arbitration in the world. Please, Domenico, you are welcome.
Good morning, everyone. Thank you for your rather generous introduction. When you were introducing me, I felt like running away because I was sure it wasn't me that she was introduced, but someone else. But thank you very much, nonetheless. Yes, there is a link between Rome and Riga, I think, and one of these is when I'm in Riga, I feel at home. I was born in Rome, but when I'm here, I really feel at home. And it's the warmth of the place, and not the weather, but the people. And the fact that I'm here today in this wonderful building and dealing with a very topical issue in international, private international law, international proceedings, and particularly arbitration. I'm very grateful for the invitation again. Thank you. Today I've been asked, I will try and speak slowly because I very much appreciate the work of the translator. I will address issues of the interaction between international arbitration and court intervention, with specific regard to the quality of proceedings. Quality of proceedings is relevant in very different ways, and of course we don't have the time to address all of them. I will focus my analysis today on the way that the quality of proceedings can affect public policy. Quality of proceedings is also relevant in terms of the rights and the interest of the parties, the legitimate expectations of the parties to be part of a meaningful and a well-run legal means of dispute resolution, such as arbitration. But that is something that does not too much impinge on the interest of a state and state courts to make sure that quality of proceedings is guaranteed. Because when we move from the interest of private parties to the interest of a state, then it is clear that that state has an interest, especially with regard to arbitration, that is a genuine alternative to court proceedings, to make sure that certain guarantees, that certain rights are protected. This is effectively my introduction to the topic and the definition of the topic that I'm going to address today. I would like to provide a general introduction on why we are dealing with arbitration these days. Arbitration is by far the most used means of dispute resolution in international trade. Almost 80% of any disputes in international trade are settled by arbitration. Some of you may be acquainted or aware of some surveys run by the School of International Arbitration at Queen Mary, and showing the results of surveys run not just with lawyers and practitioners, but with the end users of international arbitration. And all of them confirm this figure. About 80 or 90% of international contracts contain an arbitration agreement or an ADR clause, an alternative dispute resolution agreement. But arbitration, as you are well aware, is also a well-established means of dispute resolution in disputes between sovereign states. It has been like that for a very long time, and we have a long story of international arbitration used to settle disputes between states that, instead of going to war, they will resort to a third state or to an international institution to have their dispute settled. And those could be disputes about property, those could be disputes about borders between states. But arbitration has always been there. There are, of course, other important international institutions, such as the Court of International Justice, but arbitration has always been there. Now, the result of the importance of arbitration, and arbitration in this regard has been defined as one of the pillars of lex mercatoria. Without arbitration, international trade may not be just as effective as it is. And because of this importance, arbitration has been the object of legislation, both at domestic and at international level, especially in the last 30 or 40 years because of the importance that arbitration has been amassing in the last few years. We have heard already a mention to the New York Convention 1958, which effectively have provided international arbitration with a passport of universality. Thanks to the New York Convention, arbitration agreements are protected worldwide, and arbitral awards can be circulated worldwide, differently from what would normally happen with the circulation of court judgments. We in Europe are rather lucky, if I can put it like this, because we have Regulation 44/2001, which allows the circulation of court judgments on a rather comfortable fashion. But then if we take a court judgment outside of Europe, the enforcement may not be as easy as it is in Europe. The same does not apply to arbitral awards, because thanks to the New York Convention, arbitral awards can be enforced in at least 146 states in the world. Now, because of the importance of arbitration, because of the neutrality of arbitration has been entrusted with an additional role that is very important, that is the role of settling disputes relating to foreign investments. And this is why arbitration was identified by the Washington Convention of 1965 for the settlement of dispute between foreign investors and host states for the settlement of those disputes. And arbitration is also the main means of dispute resolution in bilateral investment treaties for the protection of foreign investment. Now, after this elegy about arbitration, we need to address the issue of quality. Now, it's becoming more important, it's becoming more used, and is becoming used in areas that would not be normally acquainted with arbitration. Especially in the last 10 years, we have seen arbitration being applied and adopted as a means of dispute resolution in disputes that in the past were the province of either domestic courts, domestic judges, or public authorities. What I have in mind specifically is antitrust. Is certainly an area where up to 15 years ago it would be unthinkable that an arbitral tribunal would decide whether a party breached a commitment given to the European Commission to have a merger cleared. And now we see that increasingly the Commission is imposing arbitration agreements in commitments to the European Commission under the clearance merger practice. But I will address that in a second when I will mention a case which unfortunately is not published, but we do have a bit of information about that. Now, quality. What does it mean? I think that quality, especially with regard to the realm of public international law or public policy at domestic level, impinges upon at least 3 areas. And these are the 3 areas that I would like to address in my short presentation today. The first one is certainly transparency. Domestic courts and states have an interest that a means of dispute resolution, any means of dispute resolution, irrespective of whether it is arbitration or court proceedings, provides with a degree of transparency, i.e., the possibility or the ability of the parties involved to see that justice is being done and that their case proceeds under the rules of law, and that any activity relating to the settlement of that dispute is carried out in accordance with the relevant rules and in accordance with the basic principles of that state. Now, there are two specific areas of, at least international arbitration, where transparency crops up. And one is, of course, the duty of arbitrators to guarantee independence and impartiality in the proceedings. And secondly, the duty of the state or the relevant arbitral institution administering the proceedings to provide the parties with a suitable and transparent way of checking, assessing whether the arbitrators are actually independent and impartial. And there are two emblematic cases in the last 3 years, at least, where the issue of the duty to disclose any issue that might affect independence and impartiality of arbitrators have been the object of decisions. And before I move to providing you with a bit of information about those two cases, I picked some of the most emblematic, I was about to say embarrassing, but I will stick to emblematic cases. And what is important about those two cases is the two cases had two different outcomes. But in both of them, it is clear that irrespective of the rules applied or chosen by the parties, the states and domestic courts are prepared to go beyond the agreement of the parties or the rules identified and applied by the relevant arbitration institution to make sure that quality of proceedings, in the sense that we have discussed so far, is assured. The first case is the well-known, I should say notorious, Vivendi versus Argentina annulment proceedings. This is a case arising out of the ICSID Convention. Is a case between a French foreign investor investing in Argentina, and eventually the investor brought proceedings, arbitral proceedings, against Argentina, the Republic of Argentina. There was a first stage at the end of which the award was partially annulled. There was another stage on the merits, at the end of which there was another annulment proceeding. During the proceedings, it became the parties became aware that one of the arbitrators had not disclosed a very important fact. And the important fact is that she was a board member of the main shareholder or claimant. The party, Argentina, effectively could not challenge the arbitrator because the evidence, the news about the arbitrator involvement came after the proceedings had been closed. So technically it was not possible to challenge. Now, this is an issue because it was argued that the arbitral tribunal had not been established in compliance with the Washington Convention, with the relevant arbitration rules. But the case went ahead, and the annulment committee eventually did not annul because they came to the conclusion, after heavily criticizing the arbitrator for not disclosing, that the arbitrator's exercise of independent judgment was not actually impaired, but the real reason why they did not annul the award comes and is apparent in the second and the third reasons why they did not annul. It would be unjust to deny the claimants the benefit of the award due to the arbitrator's failures and the lengthy proceedings which were initially filed in 1997. So effectively, the annulment committee under the ICSID Convention said this: you, arbitrator, were wrong, and there are some very stark pages in this award. I would invite you, encourage you to read it if you haven't done so already, because there is a very stark criticism about the arbitrator, and the criticism went beyond the criticism that had been had by Argentina in the proceedings. I must disclose that I was involved in this case for Argentina, so I mean I'm not passing judgment, but I'm sticking to what the arbitral with the annulment committee said. So there was a matter of opportunity. The award should have been annulled, but they did not feel like annulling it because then the parties would have paid the price. A long-running case. At that time, it was the longest-running case amongst ICSID arbitration proceedings. It had been running for about 10 years, actually 12 years. Now, the second case that I want to address, where we have the involvement of a domestic court, is the case of Tecnimont AVAX, ICC arbitration, International Chamber of Commerce arbitration. And at the end of the proceedings, or throughout the proceedings, there was a challenge to one of the arbitrators, and the challenge was grounded on the fact that the law firm of that arbitrator had been given advice to a parent company of one of the claimants. It's pretty similar to the Vivendi case, but we are not in investment arbitration, we are in commercial arbitration here. There was a challenge to the arbitrator, and the challenge was rejected by the ICC court without giving any reason for that. But not because of the case, because as you all know, under ICC arbitration rules, the ICC court is not under an obligation to provide reasons for either accepting, upholding, or rejecting a challenge. And this is, of course, another issue that we may want to discuss, not today, I'm afraid, because we don't have enough time, but the ICC is under pressure about this because parties want to know, and arbitrators want to know, learning from other cases what they should not do when they come with issues of independence and impartiality. However, the award was challenged before the French courts, and the French courts set aside the arbitral award. Eventually, the case went to the Supreme Court in France, and the Supreme Court reinstated the award and gave it to another court of appeal to decide whether the arbitral award should be set aside. And it went before the Court of Appeal of Reims, and the Court of Appeal of Reims annulled, set aside the arbitral award, because there was an issue of impartiality, of independence of the arbitrator. Now, that is very important because we should bear in mind that we are dealing with a jurisdiction such as France, which is by far one of the most arbitration-friendly countries in the world, and they have joined the race for looking the best arbitration-friendly in the country, together with Switzerland, England, and Latvia is an arbitration-friendly country. You have many institutions, but they are really leading the pack, as they say, and they have enacted last year a truly advanced piece of legislation in international arbitration. So before a French Court of Appeal sets aside an ICC arbitration, something extremely wrong must happen. And what is important in that decision is that they clarify the fact that the issue, the obligation to disclose and to provide transparency and therefore quality of proceedings is an ongoing obligation. It's not something happening at the beginning of the arbitration, it's an ongoing obligation applying to arbitrators and all parties involved. But what is particularly important for the purpose of our discussion today is the fact that the decision confirmed the inapplicability of the ICC rules, at least for challenging arbitrators before French courts. Because effectively the French courts said, look, with all due respect, I'm not interested or I don't care whether the ICC rejected the challenge. When it comes to public policy of my country, I go beyond that and I judge on the basis of the rules of civil procedure of this country. And the attitude of the French courts of broadening the scope of the arbitrator's duty to update and disclose conflicts of interest. Now, I would really like to dwell on this, but I need to move on the second aspects of quality of proceedings, which is legality. Legality of proceedings, especially in international arbitration, has been there for many years. We all remember the well-known cases connected to embargoes or money laundering, or other issues that are, of course, against international public policy and domestic public policy. I can certainly remember the cases decided by the English Court of Appeal in the Westacre case, which was about payment of briberies, and the Soleimani case, which was a contract in breach of an embargo imposed by the United Nations. But today I would like to touch upon two more recent cases. The first one is the Sky versus RTI, or Mediaset case. The case, I was involved in this case, but the case is not public. So, the only information I can share is the information that somehow ended up in the newspapers. And what is public is that Sky, the well-known broadcaster, acquired the two satellite television broadcasters in Italy and effectively became a monopolist in Italy. But in order for this to be allowed under European Union regulations, it would have to be cleared by the European Commission. So they applied to the European Commission giving commitments, and one of the commitments, for example, was that they would provide access on different platforms to other operators. Now, one of the commitments in the provided to the European Commission was the promise to arbitrate any disputes brought by affected third parties. So third parties who felt that somehow the commitments had been breached could bring proceedings. Even though there was no privity of contract between the third party and Sky, there was no arbitration agreement between Sky and the third party. It was an open promise to the general public, pretty similar, and this is one of the issues that were discussed in the arbitration, pretty similar to the promise that states give in bilateral investment treaties for the protection of foreign investment. They say, I promise to accept arbitration proceedings for breach of this treaty. And the commitment was something like that. So this is the main feature. But the main feature of this case is the fact that the Commission and generally the European Union is really pushing for arbitration to be used in the proceedings. Proceedings that normally in the past would have been entertained by the Commission or domestic authorities dealing with antitrust. Now somehow states and international institutions are privatizing activities that used to be public in the past. Why are they doing that? There might be issues of costs, there might be issues of lack of involvement of public authorities and leaving to the private parties to settle their disputes. But this is an important factor, and this is why, and we go back to our main argument, it is understandable that states and domestic courts may want to intervene more than they were expected to do in the past, because here we are dealing with issues that impinge upon public policy, such as antitrust, such as fair or unfair competition. Okay. The other case that dwells upon European Union and therefore public policy provisions is the Raiņa case that was settled by the Supreme Court, used to be the House of Lords in England. And that case concerned a joint venture agreement which included a rather particular arbitration clause requiring any dispute to be resolved before 3 arbitrators, each of which must be a respected member of the Muslim Ismaili community. There was a reaction, of course, when there was a challenge of that clause before the English courts, because they said, oh, this is discriminatory under European Union. You cannot discriminate employees on the basis of religious belief. You cannot do anything like this. And then the issue was whether an arbitrator is an employee or not, or is an independent professional in this dynamic. And eventually the Supreme Court accepted that an arbitrator is not a person employed under a contract personally to do work within the meaning of the regulations, the European regulations, and effectively it saved one of the pillars of arbitration, i.e. the ability of the parties to choose their arbitrators. It is a borderline case, but what is important here is that once again domestic courts were allowed to intervene on a private matter, if you like, because of the relevance, the importance that international arbitration is playing in everyday business life. Now, I will move to the last part of my presentation, just a couple of minutes. And of course, I'm more than happy to take questions, I don't know, or later, I would imagine, but I appreciate that with the amount of time allocated to me, I wasn't able to really exhaust all of the issues connected to this very important aspect. But my last point is not really a comment, is a question to you, and is the issue of efficiency of proceedings. Because we have heard in the last, especially in the last 4 to 5 years, issues of, arbitration is no longer as efficient as it used to be in the past. It's getting too formalistic, it's getting too long, it's getting too expensive. Not because of the lawyers, of course, but this is a matter of fact, is getting different. Now, and there is an issue, some kind of reaction to that. And then the issue here is, can domestic courts intervene to make sure that arbitration is not too lengthy? My first reaction would be, no, why? Because the parties and the arbitrators are in charge. But then if we look closely, because the issue here is whether swift proceedings and speed of proceedings is a principle or an embedded value in international arbitration. We all tend to accept that arbitration should be fast. And arbitration is certainly fast if you come from a country like mine, where court proceedings tend to last a bit too much. But somewhere else, arbitration proves to be a quick means of dispute resolution, but it's getting longer. But then I say, is it this an embedded principle that the parties should bear in mind, i.e., the state will allow you to go to arbitration on condition that you use this tool, arbitration, in a meaningful way? Because, for example, if you go to court proceedings, you will not be allowed to drag your proceedings forever. A judge will stop you somehow, somewhere, and say, look, now we close the proceedings, it cannot last forever. The state cannot allow dispute resolution to be played with by the parties. Now, is there anything like this in arbitration? Well, if we think that arbitration is a genuine and meaningful means of dispute resolution, alternative to court proceedings, then we should accept that the same should apply to arbitration. And we see that if we look at the domestic laws of most countries, you have a time limit within which the arbitral tribunal should settle the proceedings. Then, of course, you have a system whereby that time limit can be extended, but still you have something there. There is the expression of a principle, I believe. And the same you will find under most rules of arbitration. Take, for example, the ICC rules. You have to close the proceedings within 6 months from the signing of the terms of reference. Then, of course, the ICC court has the power to extend that, depending on the circumstances. But still you have an indication, so I think there is at least a hint that arbitration cannot last forever, and the parties and the arbitrators may be in a position or are under an obligation to entertain the proceedings in a swift way. And I leave it to my fellow to discuss, I cannot rule out that in the near future we may find court intervention also with regard to efficiency of proceedings, but perhaps this is the subject for another conference. Thank you.
Thank you. Thank you very much. Unfortunately, our next speaker was not able to come to this conference, and therefore I have to give a floor to myself. So. So, the quality is a keyword of this conference and also of this session. And Domenico already mentioned 3 aspects of this quality. It's transparency, legality, and efficiency. I will move even forward and add 4th criteria, what actually was revealed yesterday by my very good friend and colleague Baiba Rodevska and her and others at the end of the yesterday's private law session, that there should be also legal certainty. And that's what I would like to discuss today about the quality and legal certainty. I will discuss about the recognition and enforcement of foreign arbitral awards in Latvia, and we will look at the quality of practice, and actually from the perspective both of councils and also of the court. And also we will look deeply on the quality of the legislation providing the mechanism for recognition and enforcement of arbitral awards, and an interpretation of those legal norms that provides this mechanism. And then we will probably come to some conclusions. So for our guests, I will just remind in which legal framework we work in Latvia. So the most important is that Latvia doesn't follow model law. So we are not we haven't taken into consideration model law and international commercial arbitration in our national legal acts. So it's influenced both the national and the international procedure in Latvia, also recognition and enforcement of foreign arbitral awards. However, Latvia is party to New York Convention, and also I will be mentioning we are party of European Convention on International Commercial Arbitration. So we have a relevant parts that assist New York Convention. It's a Chapter F of Civil Procedure Law, providing this mechanism how to recognize and enforce the arbitral awards. This chapter was included in the law, Civil Procedure Law in 1998. However, at that time, the recognition and enforcement of foreign judgments and arbitral awards were in the same part. So in those two parts, the foreign judgments and foreign arbitral award recognition and enforcement were divided only in 2004. So, and in order to discuss and illustrate this quality and legal certainty, I would like to bring two cases, and you will also see how different outcomes are of those cases. And we will look at the arguments in the case in recognizing and enforcing the arbitral awards, but also we will compare how courts have interpreted this chapter of civil procedure law. As Domenico said, we are really pro-arbitration country, so currently, I looked this morning, we have 210 arbitral institutions in Latvia, and more or less they hear around 3,000 cases per year. So the different situation is concerning the foreign arbitral award recognition and enforcement. There are only a few cases per year, and we have no official statistics because it's combined together with foreign judgment recognition and enforcement. So, but I'm aware of many of them, as this is my field of interest. So let's start with the first case. It was decided 2 years ago, and it concerns the, maybe some of you have studied this case before, so this concerned the award made by Belarusian Chamber of Commerce and Industry International Arbitration. So this award, the parties, the claimant wanted to enforce this award against the respondent in Latvia. And actually, respondent in this case, in this recognition and enforcement procedure, claimed that respondent was not the party of arbitration agreement and main contract, because we can see from the main contract that in the contract the name of the company slightly differs as from the name of the respondent in the award. The bank account and the legal address indicated in the main contract have never been to the respondent. So, and there were another little things where respondent tried to say that we were not party to arbitration agreement and we were not party to the main agreement, so the award was made illegally. However, the respondent received all arbitration documents, never objected, even replied in the course of arbitral proceedings, and never made objection that they were not the party of arbitration agreement. So, and I think the biggest problem was that the respondent could not find the qualification in New York Convention. So they relied on Convention's Article 5, Part 1, point C, stating that actually arbitral tribunal went beyond the arbitration agreement. So maybe if the respondent would read the Domenico's book, maybe the the case would end completely differently if they would find the right qualification. However, and in the first instance, the court said that yes, we have to enforce and recognize and enforce this arbitral award because there is no violation of Article 5. However, on the second instance, in Riga Regional Court, the court said no, it's a violation of New York Convention, Article 5, and the whole Article 5 was cited, and therefore this award should not be recognized and enforced. So the claimant took a liberty and submitted the complaint to the Supreme Court that actually accepted this case and reviewed this case, stating that actually there is no violation of New York Convention. This is not a question of New York Convention, but it's a question of European Convention on International Commercial Arbitration, Article 5, Part 1, that states that if you want to challenge the jurisdiction and if the arbitration agreement is invalid or void, you should do it during the proceedings, but not later when you have to submit the statement of defense. So the Supreme Court decided that foreign award shall be recognized. So that's the first case. The second case, and I have to say that I have no involvement in the second case, and I'm just giving my perspective as a lawyer or for the purpose of this presentation. So this case concerns the Stockholm Chamber of Commerce Arbitration Institute award. And I think that Latvians are very unlucky with Stockholm arbitration. I guess it's around 90% cases when Latvia loses in Stockholm. Or either if we win some cases in the Stockholm, then they never get recognized and enforced in Latvia. So the statistics extremely negative, and and this case also is kind of having those both components. The claimant in the Stockholm arbitration became a respondent in Latvian enforcement and recognition procedure. Namely, the claimant brought the claim in Stockholm, but they got the counterclaim, and the respondents partially won this counterclaim. So, and the respondents in arbitral proceedings came to Latvia to recognize and enforce this arbitration award against the initial claimant. So, and in this procedure, the respondent said that there was a violation of due process during the arbitration. Namely, there were three aspects. The one was that arbitral tribunal did not accept all evidences what they needed. Actually, the arbitral tribunal refused to go for the site visit. Second was that arbitral tribunal applied ABA rules on taking of evidences in international commercial arbitration, even though the parties have never agreed to use such rules. And one of the other reasons was the parties during the arbitral proceedings agreed to change the place of arbitration from one country to another. However, the arbitral tribunal did not follow this agreement. So, and consequently, if there is this due process violation, also there is the award was made against the public policy of Latvia. So it's Article 5, Part 2, B of New York Convention. So in the first instance, the judge decided to recognize and enforce the arbitral award. However, it was of course appealed in the Riga Regional Court, and Riga Regional Court decided that there was violation of due process, and as tribunal did not accept all evidences, and tribunal applied ABA evidence rules, however, but the parties have never agreed to those rules. There was no discussion in those awards whether the respondent in these proceedings have ever objected that during the arbitration proceedings, and they never did that. So, and it's also, there was no discussion whether those violations of due process ever influenced the award, the result of the award. And of course, taking probably into consideration the previous case, the claimants, as Riga Regional Court did not recognize and enforce the award, they brought a complaint to the Supreme Court. However, the Supreme Court did not accept this case, stating that they have that we have to carefully look at the law, and law says that there is no three-tier appeal system. There's only two instances that may review the recognition and enforcement of arbitral awards. Now look at this, we are turning to the second part of my presentation. Look at this clause in the law. What made actually so different decisions of the Supreme Court. So, Section 5 of Article 649 of Civil Procedure Law provides that a complaint, so blakus sūdzība, can be submitted regarding the court's decision to recognize or not to recognize the arbitral award. And complaint is kind of equal to appeal, but it's on the procedural aspects. So, yes, I agree that we may interpret this clause that there is only one possibility to appeal against the decision on recognition and enforcement. However, this clause does not specify which instance, whether it's first or second, so we probably may also interpret very broadly. Yes, I also acknowledge that in many countries there is no three-tier appeal system for such decisions. However, I have two other concerns. One, of course, is this legal certainty. There's no both of those decisions, also the first one, was published in the webpage of Supreme Court. So we consider it as a judicature, as a precedent. So you can rely on that. This is legally certain that actually the Supreme Court probably will accept the next time also your complaint. Moreover, the Supreme Court is the highest instance who can make this judicature and this precedent, and also applying such an important instrument as New York Convention. But the second and the most important thing is that in this decision, the Supreme Court, and I really apologize to the Supreme Court justices here, but they compared the national system of submitting the complaint and this system what is incorporated in this chapter regarding the recognition and enforcement of arbitral awards. And I think probably by analogy we had to take those norms and legal norms that provides for the international civil procedure law and other chapters of civil procedure law, because the domestic national rules regarding the complaints are not suitable for international civil procedure, namely because it's completely different legal technique and it's multi-stage proceeding in recognizing and enforcing the arbitral awards. It's not only just to accept and have a proceedings, but also it's evaluating whether we accept this foreign award or judgment in our system, in our legal system. So we evaluate the non-recognition grounds, and it's completely different than it's in a pure domestic system. So we see those two different cases. Also, those cases reflects problems, awareness of applying the New York Convention by councils, by the representatives of the parties. And also it reveals the gaps what we should fill in our national legal system helping New York Convention. Therefore, I would suggest that we need some kind of legal certainty how we proceed with recognition and enforcement of arbitral awards, and I would suggest to interpret this chapter systematically and autonomous from the domestic procedure. And in conclusions, I must admit that Latvian lawyers should not invent the bicycle again and again and again. The councils may look at the commentaries, and a lot of commentaries and a lot of case law on New York Convention, and choose the right qualification, right article of New York Convention. And I also suggest that actually the legislator could just look at the chapter on recognition and enforcement of foreign judgments and probably get the influence from that chapter of the civil procedure law and change the accordingly the chapter in the regarding the enforcement and recognition of foreign arbitral awards. So thank you for your attention. That was my observations regarding the Latvia's system of arbitration, enforcement and recognition of arbitral awards. Yeah. Actually, at this point, I want to break this private law session, and I would like to start the public law session, because I think we are all keen what happened in Georgia in elections. So, well, I'm very proud to invite to this podium Sophie Makaladze, who is actually also teaching at Tbilisi State University. She teaches both international arbitration and international sales law. She coaches for many years with international commercial moods for Georgia team, and now currently she works for USAID, Founded Judicial Independence and Legal Empowerment Project, and she is in charge of assessment and analysis of framework and development of various programs aiming to raise awareness and improving the practice of arbitration in ADR. So Sophie, I would welcome you here. Maybe you can briefly give us, the insight of the elections and also how it will implement the arbitration environment, probably. Okay? So.
Well, thank you very much, Inga. I'm very happy to be back to Latvia and back to this beautiful building, and I would like to thank all the organizers and especially Inga for giving opportunity to be back here. And I'm happy to be back from a democratic Georgia, where first time in the history of Georgia the government has been changed by the way of elections, and that is a big achievement for Georgia. And I very much hope that that will have at least some influence on the way arbitration will be developed in our country. But before I start, I would like to clarify that today I'm here in my private capacity. Therefore, the views expressed in my presentation are not those of the university or the project I work for. And the topic of my presentation today is the new law of Georgia on arbitration. And in order to validly assess the importance of adoption of the new law, I will briefly give an overview of the background that preceded adoption of the law, and how the poor quality of an act may outlive the act itself and have an influence on even the practice even after that law is no longer in force. I will then give a brief overview of the main features of our law and some issues of concern which relate to the way the law is applied in practice. And then in the end, I will conclude with some of my perspectives for how arbitration can advance in Georgia. So before adoption of the new law, arbitration was governed by the law of Georgia on private arbitration of 1997. And the act had many shortcomings, but I will only address those main features which still affect the way arbitration is run in Georgia. So 1997 Act required that all permanent arbitral institutions be registered as commercial entities. The arbitral awards were readily enforceable without any reference to courts, so there was no recognition and enforcement procedure for arbitral awards. But what the law allowed was the change of the awards by the courts, and the ground for such change, the basis was quite obscure. And in the end, the law did not designate the courts authorized for intervention or for the change or for recognition and enforcement of foreign awards. And although the New York Convention is enforced in Georgia since 1994, the law did not incorporate any of the provisions of the New York Convention. So that caused several problems. One of the problems is that arbitration has become a business. Even today, there are a bit less than in Latvia, because there are around 150 companies which are arbitral institutions. And in effect, these are companies which try to attract clients and thereby become inherently biased towards those clients whom they try to attract or retain. The fact that arbitration awards were readily enforceable had resulted in quite a few number of fraudulent arbitrations, where even arbitrators themselves would be involved. And for example, the two parties would bring a claim over a property which belonged to neither of them, and then the arbitrator would grant an award giving ownership to a property which never belonged to any of the parties. So the parties would acquire interests in something that was never theirs. So the multitude of such and other fraudulent arbitrations has really caused discreditation of arbitration, with which we are still struggling in Georgia with that perception of arbitration. The practice of change of awards. Now, even though the current law has no such provision anymore, and in fact it closely follows the provisions of the model law on setting very limited grounds for challenge, there's still a tendency in Georgian courts to change the awards, and I will speak later about that. And as to the foreign arbitral awards, as I said, even though the New York Convention was enforced in Georgia since 1994, and it did not require any implementing legislation, under Georgian law it could have been readily applied. Because there was no implementing legislation, there was no awareness on the part of the judges, so very often they would recognize and enforce foreign arbitral awards referring to the law on private international law of Georgia, which regulated enforcement of foreign judgments and not foreign awards. So that also has affected the fact that New York Convention was not very often referred to in our court judgments. Well, with this background, adoption of the new law, which is based on the UNCITRAL model law, is a significant achievement. The law applies to both domestic and international arbitrations. It clearly designates the courts which may have any role in arbitral proceedings, starting from assistance to the arbitration and as well as recognition and enforcement of both domestic and international awards. It has many discretionary provisions, it respects party autonomy, and in all respects it really very closely follows the text of the model law, including the limited grounds for recognition and enforcement of awards. There are very few deviations from the model law, and I will outline 3 of them here. The writing requirement. The law recognizes follows the same line as the model law, saying that writing requirement is complied with by if the arbitration agreement is made by means of electronic communications or by exchange of letters of statements of claim and defense, but that is not valid when parties to arbitration are on the one hand a legal entity and on the other hand a natural person or an administrative agency. And in those cases the law requires for agreements to literally be in writing. And if the parties are both natural persons, then the law requires the agreements to be countersigned by parties' attorneys or certified by notary. The explanatory note states that these changes, these provisions aim at protecting the consumers, but I will argue later that the restricting writing requirements do not really protect consumers from consumers. Another deviation is the effect that is given to the arbitration agreements. Under the model law, a court must stay proceedings and refer the parties to arbitration if a dispute is subject of an arbitration agreement. The law of Georgia, Article 9.1, states that the courts before which an action is brought on a matter which is subject of an arbitration agreement will refer the parties upon receipt of notification about commencement of arbitration hearing. Therefore, it sets commencement of arbitration hearing as a prerequisite for referral of the parties to arbitration. Now, this flaw of the law may in no ways be really followed, and fortunately there is no practice which follows this for 2 reasons, because as I already said, Georgia is a party to the New York Convention, and Article 2 of the New York Convention supersedes actually the state law, and so this contradiction must be resolved in favor of giving effect of an arbitration agreement. Another example is also that when adopting the new law, the changes in the Civil Procedure Code of Georgia were also made, and the provisions of the Civil Procedure Code of Georgia clearly state that existence of an arbitration agreement is a ground for dismissal as well as for termination of court proceedings. Therefore, there is a collision, and hopefully this flaw of the law will be cured, and hopefully it will not affect the practice. And finally, under the model law, a court may suspend its decision on setting aside of an award only if the award has not yet become binding or has been set aside in a court where the award was rendered. Under Georgian law, the court may suspend enforcement of the award by mere application of a party which provides an appropriate security. But other than this, we have a very good law, and I think the main it is a very good law, and I think the main advantage is that today we can say that the world knows the law of Georgia because the world knows the UNCITRAL model law, and that is a very big advantage for Georgia. But one thing is to know the law, and another thing is to know how the law is applied in practice. And I will address the two issues of practice of Georgian courts, which hopefully will be changed. And those two issues that I will address only concern domestic arbitrations. They have not been exercised with respect to international arbitrations, and hopefully that approach will be changed with domestic arbitrations as well. So the first practice regards the way how validity of arbitration agreements is treated in Georgian courts. An agreement providing for private arbitration in accordance with the law is considered to be insufficiently precise and invalid. When an agreement provides for arbitration or litigation at the choice of one of the parties, it is considered as a not specific enough choice of arbitration by the parties. And even when the choice of arbitration is specific and single without alternative to litigation, but which leaves the room to choose a specific institution by a party, one of the parties, it is still considered as not specific clause to give effect to, and is considered as invalid. So in all those cases, the court considers that there is no express and definite will of the parties to subject their dispute to a specific arbitration institution. Now, the real problem with all of those cases was actually that in all those cases, the parties were, on the one hand, a bank or a financial institution, and on the other hand, there was a natural person or a small business. And so in most of those cases, the arbitration agreements were contracts of adhesion, where a party was forced in an arbitration which another party would choose. So it was a favorable arbitration to the other party who had the choice under the clause. So, and often this was the way the courts would protect those weaker parties from what they considered as unfair arbitrations. Now, the problem with that reasoning is, for me, is that there is a problem here, but the cure that the court provides is somewhere else, and that creates additional problems. Of course, once this line of reasonings of the courts appeared in Georgia, those banks and financial institutions started to note specific arbitrations in their arbitration clauses. So the justification of the court that there is no specific institution mentioned is not valid anymore, because there was a specific there is now often specific arbitration institution noted already in the clause, but that does not really solve the problem of uninformed and unwilling parties being forced into arbitrations. Even more, such interpretation puts under question ad hoc arbitrations, because when parties opt for arbitration, and if that is their will, unless they designate a specific arbitral, so the court actually requires designation of a specific arbitral institution. But what if they don't want an institution, but they want ad hoc arbitration? So that interpretation really endangers the livelihood of ad hoc arbitrations in Georgia. And of course, it undermines the effect of arbitration agreement when we would deal with parties with equal bargaining power. So when the will of the parties is true and is valid, the parties could find an escape from arbitration, relying on the reasoning that there is no specific arbitration clause mentioned. Another practice relates to the way public policy is interpreted under by Georgian courts. And in many instances, this is a very correct application when we deal with the conflicts of interest or when we deal with the procedural injustices. But the two practices which I would like to address now are the following. The court considers, when the arbitral award deals with grants high interest rates to a party, when such interest rates were envisioned in the contract, or when under arbitral award a property is directly transferred to a creditor, Georgian courts consider that these such awards contradict basic principles of the law of obligations of Georgia, and therefore they violate the public policy. The problem is that the provision in the law of obligations of Georgia states that a court may reduce unreasonably high interest rates. When parties subject their dispute to arbitration, the only court which may exercise this discretion is the arbitration court. And when the courts of law find that arbitrators erred in application of that provision, and they start revisiting this is nothing but intrusion into the merits. And even more so, here we see the effect of the changing of awards, because the courts themselves reduce those interest rates to what they consider is reasonable. And even a bigger problem is that in those analyses, the court does not provide analysis what is a public policy or why that contradicts public policy. So that really leaves the door open to considering any so-called incorrect application of any provision of the law of obligations or any other law as against public policy. And that is something that really does not fit into the spirit of the model law. So some of the steps that I see for future is that the problem of the weaker parties from forced arbitrations should be dealt with differently, not by invalidating the clauses and not by invalidating the awards under public policy, rather by considering those clauses maybe as unconscionable as contracts of adhesion, or maybe by adopting a regulation protecting consumers against pre-dispute arbitration clauses. Also, a code of conduct and some self-regulation of the profession would raise qualification and accountability of arbitrators. And then eventually our judges, once the cases start to go, the cases where the parties would really subject their dispute to arbitration, the courts will really need to demonstrate that they respect and support arbitration and really stick to the very limited grounds of intervention. Now, when the law was adopted, it was said that new law is adopted for the purposes of promoting arbitration in Georgia. And there are two other aspects which need to also be addressed if we want really to promote arbitration. And one is that the fees for recognition and enforcement are very high. They are the same as the parties would go and litigate the case to the full extent. So the job of a judge litigating case to the full extent really differs from the job of a judge when they consider awards for recognition and enforcement, and therefore the fees for recognition and enforcement should be reduced. And another problem which is present in another law is the Criminal Code of Georgia, which equates the status of arbitrators to those of the public servants when we deal with the offenses of abuse of public authority or excess of public authority, and that really may undermine the independence of arbitrators or the willingness of arbitrators to serve at all. So I've talked mainly about the problems of arbitration in Georgia, that in no way should be understood that there is no future of arbitration in Georgia. And to the contrary, I very much believe that the new law is a really new triggering point for Georgia and a unique opportunity for Georgia to reform its practice. And all it takes is a will and strategy, because the problems are identified. And I think we really need to take this chance and to make Georgia friendly and popular venue for dispute resolution, all the more that we have successful line of reforms A few days ago, we have demonstrated that we are a democratic country. We have infrastructure. We have many natural gifts as well, which make us unique in the region to become maybe even a regional seat for arbitrations once some of the challenges are addressed. Thank you very much.
Thank you very much. You saw that the common trend actually in arbitration law is that arbitration specialists are not only great academics, but they are also great practitioners, and they have to combine the practice and academic life. So I'm glad to introduce you the next speaker who also combines those two things. So Alexei Anishchenko, he is a boss lecturer at Belarusian State University, but also a well-known practitioner, partner of Soren and law firm. He has a lot of publications, and he has given many presentations on arbitration and the commercial matters, both in Belarus and worldwide, I would say. Alexei, you're welcome. And we are turning from arbitration to mediation, but how many arbitration institutions before you start?
You are still in my presentation already. We are not yet to compete with Georgia or Latvia, but we are actually already 14, which would not be really something to believe even like 5 or 6 years ago. And generally, like by way of introduction, I should say that if somebody will approach me a year ago and say that I will be speaking at the international conference about the quality of legal acts, I would think that this is a good but still a joke. But by the same token, if somebody would tell me 5 years ago that there will be a draft law on mediation in Belarus, I would also say that it is a joke, but a bad one, and a cynical one, because I'm personally a big fan of the ADRs. And this is basically how it came to this presentation. And I, of course, would like to thank the organizers and Inga in the first place for this nice invitation. And next 20 minutes, I would share with you the story. Like, contrary to my distinguished colleagues who were kind of going very much in depth of the legal analysis, I would rather be more like on the surface, but again, sharing with you the story which many my colleagues in Belarus are still perceiving rather as a fairy tale or a miracle rather than the reality. To begin, and this to a large extent explains the title of my presentation. So to begin with, why there is a heaven and what is meant by the heaven. By way of just few general comments, we have a dual court system in Belarus, and we have two separate system and instances with ordinary courts, or civil courts as we say, that deal with the civil matters and criminal matters, and a separate system of commercial courts, and each of the system has its own Supreme Court. And very, well, relatively cheap and very fast state courts. And here I think we are ahead of the planet with the maximum 2 months for the first instance, and well, in a rare case, more than 6 months for all 4 instances. So it's kind of the very, let's say, fast track consideration of the disputes. And because of that, traditionally arbitration, especially for even arbitration, especially for domestic cases, were not really perceived as an alternative. It was just like some nice and expensive tool for sophisticated lawyers who just want to earn some additional money. So that is not a surprise that until August 2004 there was no ADRs at all, maybe save for primarily international arbitration, which still was not much tolerated by the state courts, and the situation was much similar to Russia. particularly when it comes to the issue of recognition and enforcement of foreign arbitration judgments. But another interesting thing was the heavy caseload, and particularly in the commercial courts. And in the year, for example, in the year 2010, there were two judges in the Minsk in the Minsk Commercial Court who actually resolved more than 1,000 cases per year. So just by simple maths, you can imagine that they have had to consider and render the judgment like for 3 cases per day, which is difficult really to imagine. And one could ask where is the heaven for arbitration and ADRs and how it could be. But the help came actually out of the blue, and to be more precise, with the financial crisis. The good thing for arbitration in Belarus. What happened is that actually because of the increasing caseload, and these 1,000 cases were really too much even for Belarusian judge, and the judges started to complain, so the Supreme Commercial Court faced the challenge, because of the crisis they were refused an additional financing, and they were not able to invite and to have more judges. So at the same time, where it was kind of the imperative to keep the same speed and the cost of proceedings. So in such circumstances, the alternative dispute resolution appeared to be actually the ideal solution. And it was exactly the Supreme Commercial Court of Belarus who actually started to promote different means of IDRs in Belarus, and succeeded pretty much. So by today, we had more than 60,000 in-court conciliation. So Supreme Commercial Court has actually started with the so-called in-court procedure. So the judges were, the so-called conciliators were the employees of the court. They were not judges, but still certain lawyers employed by the courts. And this practice proved to be quite successful. So more than 75% of cases were settled, and around 90% were executed voluntarily. And this allowed the Supreme Commercial Court to start the trial project with out-of-court conciliators, and it also proved to be quite successful. So that all created quite an ADR-friendly environment, resulted, for example, in the adoption of the new law on arbitration, on domestic arbitration. So now we basically have 2 laws, one based on the UNCITRAL model law devoted to the international commercial arbitration, and the relatively new one of 2011, the law on domestic arbitration, that actually created the platform for setting up more local arbitration courts. But still, that is not about the law of mediation, and it was not an easy way to go. The first step was actually the concept of optimization of commercial procedure, which essentially may be compared with the kind of the green or white paper in the EU, which was drafted by actually a few practitioners, and then submitted to the Supreme Commercial Court, and it was never formally adopted, but actually created a platform for quite a substantial reform. We used to have the so-called Chapter 17 in the Code of Commercial Procedure that actually provided for in-court conciliation. And this chapter, being introduced in 1998, for many years proved to be stillborn. But again, with this, with the crisis and with this initiative, finally the Supreme Commercial Court started to use this procedure, and as I already showed it proved to be a big success. Then finally, after numerous attempts to introduce the mediation as such into the court system, which actually failed, and a few times the legislator was refusing to include provisions on mediation in either in the amendments to the commercial procedural court or in this new law, because initially the draft law on domestic arbitration included also conciliation, but again it was refused mainly on the basis of principles of systemacy and complexity, which under the Belarusian law requires the kind of the complex legal act for any new area of relations which is subject to the legal regulation. And that is why finally the draft law on mediation was included into the so-called plan of drafting laws for 2011. This is how the things are done in our country. And as you may see from the slide, over 2 years there were at least 3 official revisions of the draft law, which basically shows how controversial and how difficult it was even for the Supreme Commercial Court to put the draft law through all the stakeholders. And the draft itself was developed by the working group consisting of the representative of the Supreme Commercial Court, the Supreme Court, and National Center for Legislation and Legal Research, which is the governmental authority responsible for particularly for the quality and for the development of the legal acts to be then submitted to the legislature. But the specific feature of the Belarusian way of developing laws and passing them is that actually the most of the work is being done not in the when the bill is in the parliament, but rather before, when all the interested state bodies are invited to comment on the law. One could debate whether it is good or bad, democratic or not, but certainly this approach has its own advantages, because in many instances and in many cases we saw that when those state bodies are not invited in that kind of negotiations of the draft law, then after the law is being passed, and in Belarus it sometimes happened with the presidential decrees, that actually all those state bodies are starting to kind of undermine the whole effect. And by the end of the implementation phase, basically the baby is thrown away with the water. And here it was actually totally vice versa. So the main interested bodies included the General Prosecutor's Office, the Ministry of Justice, the Committee of State Control, and most importantly the Presidential Administration, which basically is the body that accepts the bill before it goes to the parliament, which in practice not guarantees but gives the real hope that the law will be successfully passed finally. And again, what differentiates this particular draft from many other ones is that the legal community was invited to comment and actually participated quite intensively. So all the drafts were officially published, the public was invited to provide their comments, and many practitioners actually participated in that process. Surprisingly, not always in a very effective way, because because of many controversies and the many highly debated issues, the question which was faced by the Supreme Commercial Court was actually what is good, to have the imperfect law or not to have a perfect one? And this is actually the question that I would be very much interested in the same way as Domenico did to give to the audience. Because if somebody is interested in WTO law and its principles, actually the principle of so-called constructive ambiguity was one of the principles which actually contributed a lot to the creation of the system. So again, it's still an open question, but here in some of the key critical issues which were discussed and amended during the work on the draft, this particular approach was taken. First of all, first issue was the level of so-called jurisdictization, which by itself may be considered as a kind of oxymoron, but the idea is pretty simple. In order to make mediation work in practice, you have to find a certain balance between the public interest and private interest, and to give them, the mediators and the parties, certain flexibility. So you cannot really legalize and regulate the process in every aspect. But of course, in the country like Belarus, when the state interference also in the private relations is quite strong, you cannot really hope for the full flexibility and to leave everything to the, for example, self-regulated organizations, which was actually proposed in the very first draft. So. Another issue was the types of the disputes eligible for mediation. And here again, on one hand, the critics were very much concerned of extending the scope of such disputes, for example, to family dispute, to labor disputes, and at the ultimate to the administrative disputes. And what actually has been done, and in the draft which has been approved in the first reading by the lower chamber of our parliament, now it's actually there is no clear answer. So there is no prohibition, and I personally believe that if the law is approved as such, there will be no problem to, at least for civil disputes, all types of civil disputes, and also the family and labor dispute to be mediated. But even more, the last version provides for the possibility, with the approval of the competent state body, to mediate even administrative disputes. So the disputes where one of the parties is the state entity, which, again, 4 years ago, if somebody would tell that, it would be unimaginable. More practical issues relate to the level of state control on every aspect of qualification requirements, and ensuring the quality of the mediators, the protection of the weak parties, and also a certain level of control of the conducting of mediating activities. And here, for example, the debate on qualification requirements was surprisingly most of the state bodies which I mentioned were insisting that only lawyers can be mediators. And here again, it was a surprise that actually Supreme Commercial Court has taken a different position. So they insisted to give the possibility to other professions being involved, and in the current draft it actually left open. So it said that the person holding the high education in law or in other area may qualify as mediator, provided that it undertook either additional training in mediation or worked as the court conciliator for at least 2 years. So again, kind of the reasonable compromise. Of course, in terms of qualification process, there was much debate whether, again, it should be controlled by the by the professional organization of mediators or the state, and here, not a big surprise, the Ministry of Justice was assigned a role to be responsible for keeping the register of mediators and for organization of the work of so-called Commission for Qualification. See, my time is running out. Then mediation rules and codes of ethics. Here the mediation rules were left for the mediation organizations, but the government is supposed to draft certain standard model rules which must be then followed. Agreement on mediate and effect on the limitation periods very much go together, because the solution finally was to consider the agreement to mediate as a separate agreement. So under the current draft, the ADR clause in the contract will not be considered as an agreement to mediate, which in turn suspends the limitation period. So under the current wording, when the parties in dispute have to sign the separate agreement to mediate in order to suspend the limitation periods. But probably the most exciting thing is the settlement agreement. And here the Supreme Commercial Court actually made another revolution, because essentially they managed to divide the settlement agreements in two types. And if the settlement agreement reached in mediation actually satisfy the criteria of settlement agreements under the Code of Civil or Commercial Procedure, then basically it have the effect of the settlement agreement in the court, i.e. it does not require a separate proceedings. So it's being submitted to the court, and the court can grant the enforcement order without reconsideration of the dispute. So it's basically the direct enforcement. And let's see if these provisions survive in the second reading. So the key factors which contributed to the overall success of the process was, in the first place, of course, actually a human factor, because if not professional and also to a certain extent personal interest of several judges and private practitioners, then probably there will be no energy to put the draft through all the layers. But also, what is most important was the right path chosen by the Supreme Commercial Court, compared, for example, to the Russian practice, which is still perceived to be a negative one because their law is not working in practice. So in Russia, they started with the law and then tried to see how it works in practice, whereas in Belarus, they use actually vice versa. So they started with the in-court conciliation with the big level of control by the courts, and then showing the positive results. It was much easier and much understandable to the government, to the legislator to put through. And actually, the wise use of existing experience, not only with Russian law, but in the first place with the EU directive, which is actually cited in the explanatory note to the draft law much more often than the Russian law, is an example by itself. So what's now? Now we are expecting the second reading in the Parliament, in the upper chamber, in the fall of 2012. If everything goes well, then it will be signed by the President, and 6 months for implementation, so for acceptance of all legal acts in which should set up in the first the institutional structure for conducting the mediation activities. What are the risks? And here I couldn't resist the temptation to use the cartoons, which I have to admit that the idea was stolen from Inga some years ago. So the first risk, and I apologize for the Russian wordings, I tried to translate, and the first risk is that still in the upper chamber the decision will be made to amend amend and to improve the laws, but the risk is that it will be given, for example, to Ministry of Justice, which is supposed to be the entity to conduct all the activities, and they might not be very much interested in doing that. Here the slide says that the law on corruption is supposed to be given to the corruptionist for development. And the second, more realistic risk is that the amendments to the law will again may diminish the real essence of the law. And here, like you see, that the nice law being amended is very much concerned about its weight. But still, again, I of course do not want to end up with any kind of negative things, and this draft was with no doubt and one of the very few examples in the modern Belarusian legislative experience, particularly in the commercial area, when it was developed, discussed, and accepted, yet only in the first reading, in my personal, again, this is my personal, of course, opinion, proper way, through thorough discussion, preparation, involving not only the state institution, but academic, professional community, effective public debate, effective use of experience in this area of our neighbors, namely the Russian Federation, European Union. And that is why I personally believe that the tier, so why tiers, you may see that it wasn't an easy process, and honestly when I decided to make this presentation there was a big risk that the tiers will still be that of sorrow and not that of happiness, which now I think there is little to believe will be different. Thank you.
Thank you. Thank you, Alexei, for your observations. I think it's becomes topical in Latvia as well to discuss about the mediation. However, with a great help of our distinguished experts, we have traveled around the world of dispute resolution, but now we end up to another topic, and I would like to introduce you with Irena Kucina. She is working for the Latvian Ministry of Justice and just recently became a director of Department of Cooperation with European Court of Justice. Till that, she was head of Division of Private International Law of the Ministry of Justice. She is also my colleague at university at our International Law Department, and she has defended her dissertation on international child abduction. So, Irena, give us back to another fields of international private law.
Paldies! Sveicināti! Atļaušu jums pārslēgties droši vien uz latviešu valodu, tulkiem tagad sāk darbu drusku citādākā režīmā. Un šodienas tēma tātad tiesiskās palīdzības līgumu kvalitātes mēraukla. Kāpēc izvēlējos tieši šo tēmu? Uzgaidīšu kolēģis, jā. Mēģināšu jums pamatot, kāpēc, bet droši vien jūs gribētu arī pajautāt sev. Vai šie līgumi, tiesiskās palīdzības līgumi civillietās un krimināllietās mums gadījumā jau nav aizmirsti? Vai mēs par šiem tiesiskās palīdzības līgumiem mācamies universitātēs? Vai tomēr ir tā, ka kāds no mums kaut ko par tiem zina, piemēro, ieskatās, palasa? Vai tomēr ir tā, ka beigās ir Eiropas Savienība, mums ir virkne Eiropas Savienības regulu, un mēs vispār nevaram un nedrīkstam šos tiesiskās palīdzības līgumus piemērot? Jautājumu ir gan daudz, un principā ar savu prezentāciju es varētu atvērt jau diskusiju, bet iesim soli pa solītim uz priekšu un mēģināšu arī attiecīgi uz šiem jautājumiem, ko es arī uzdošu, gan jums, gan sev, atbildēt un sniegšu šo savu redzējumu. Tātad, tiesiskās palīdzības līgumi civillietās un krimināllietās noslēgti Latvijā 90. gadu sākumā. Un iedomājamies, cik ilgi šie līgumi Latvijās ir spēkā, diezgan daudz, un daudz ilgāk nekā Eiropas Savienības regulas. Un pēc savas būtības visi šie līgumi ir tipveida. Ja jūs atšķirsiet tiesiskās palīdzības līgumu, piemēram, ar Poliju, salīdzināsiet to ar Krievijas tiesiskās palīdzības līgumu vai ar Lietuvas, Igaunijas, Moldavas, redzēsiet principā copy-paste variantu. Tādā ir tā doma bijusi attīstīt starptautiskās privātiesības nacionālajā mērogā, sadarbojoties vispirms jau ar trešajām valstīm, kas pa lielu mums ir kaimiņu valstis, tātad Baltkrievija, Krievija, un, protams, runāt un attīstīt starptautisko privātiesību jautājumus ar Lietuvu, Igauniju un Poliju. Lūk, kā rezultātā jūs redzat, mums ir noslēgti vairāki līgumi, tātad ar Krieviju, Ukrainu, Baltkrieviju, Uzbekistānu, Kirgīziju, Moldovu, Lietuvu, Igauniju un Poliju. Un jāpavērot un paskatīties, salīdzināt statistiku, grāmatā konkrēti būs šī statistika pieejama. Tiesiskās palīdzības līguma piemērošana Latvijā arvien pieaug. It īpaši šo līgumu piemērošana ir aktuāla sprieduma atzīšanas un izpildes jomā, tas ir viens, un pārobežu dokumentu izsniegšanas jomā. Tas nozīmē, ka vienas valsts tiesneši pārsūta tiesas dokumentus, otras valsts, iestādēm un šādā veidā īstenot šo tiesisko sadarbību. Līguma darbības joma ļoti plaša. Mums nav izdalīti tiesiskās sadarbības līgumi tikai civillietās vai tikai krimināllietās. Tā ir ļoti plaša. Bet šodien es gribētu runāt par civilu tiesību jautājumiem starptautisko privātu tiesību aspektā. Un civilu tiesību jomā ir aptverti tādi jautājumi kā jurisdikcija, piemērojamais likums, sprieduma atzīšana un izpilde, dokumentu izsniegšana, pierādījumu iegūšana. Tātad jurisdikcija, kuras valsts tiesā celt prasību, piemērojamais likums, kuras valsts likumu piemērot, nākamais, ja ir mums spriedums, kurš noteica, piemēram, kādam apmaksāt tādu un tādu summu, tātad kā es šo spriedumu varu izpildīt citā līgumslēdzēja valstī. Un, protams, arī šī tiesiskā sadarbība, ko īsteno tiesneši dokumentu izsniegšanā un pierādījumu iegūšanā. Negribētu iet detaļās un stāstīt par līguma normām, pantu pa pantam, bet patiesībā izvirzīt problēmu jautājumus. Un pateikšu jums godīgi, arī no savas puses atbildes ļoti ilgi meklēju, un konkrētu atbildi jums nevaru sniegt, bet varu dalīties ar savām pārdomām, pārdzīvojumiem līguma piemērošanā. Jāsaka, paldies jums, es šeit zinu, zālē ir gan tiesneši, gan praktizējoši juristi, gan arī studenti par to, ka jūs šos visus jautājumus aktualizējat. Un tikai jāsaka, burtiski pēdējā gada laikā mēs esam sapratuši, ka šie līgumi tomēr, un tas jau tā kā tuvāk nonāk līdz secinājumam, neatbilst mūsdienu starptautisko privātiesību attīstībai, un mēģināšu izstāstīt, kāpēc. Pirmais, kāpēc, un atbildot šo, ir tas, ka šie tiesiskās palīdzības līgumi vairākos tiesību jautājumos rada nenoteiktību, tā mēs runājam šodien, tiesisko nenoteiktību, un puses patiesībā nezina, arī tiesneši nezina, kā tos piemērot, un puses nezina, kā tos līgumus, piemēram, arī izmantot. Un otrs, kāpēc, un atbildot uz to, Eiropas Savienības prasības. Un pie tā es nedaudz atgriezīšos vēlāk, tātad sāksim ar šo pirmo posmu. Neatbilstība tātad mūsdienu prasībām, jo mūsdienu prasības starptautisko privātiesību jomā ir tiesiskā noteiktība, lai mēs zinām konkrēti, kuras valsts tiesā celt prasību, kā mēs šo ārvalsts tiesas spriedumu varam atzīt un izpildīt, lai visiem viss ir skaidrs. Lūk, pirmais jautājums, ko es gribētu uzdot, nepiedāvājot atbildes. Atbildes varēsiet izlasīt grāmatā, bet vienkārši padalīties ar jums attiecīgi ar saviem atbilžu variantiem. Tātad, vai Latvijas nepilsoņi bauda tiesisko aizsardzību, kas paredzēta tiesiskās palīdzības līgumos? Ļoti sensitīva joma, ļoti sensitīvs jautājums. Gari nerunāšu, bet došu jums piemēru. Piemēram, kolēģis Aleksejs, būdams Latvijā, aizdot personai A, kas ir Latvijas nepilsonis, kādu naudiņu. Kā rezultātā šī naudiņa, nedēļas laikā jūs te sarunājat, kā tiks atdota, netiek atdota. Arbitrāžu. Jā, mēs varam runāt par arbitrāžu un tā tālāk, bet es gribētu runāt par to, kas nav saistīts ar arbitrāžu, izslēdzot šo jautājumu. Tātad, ko darīt Aleksejam? Mums ir tiesiskās palīdzības līgums ar Baltkrieviju, atceramies, un Baltkrievija ir šajā sarakstā. Tātad Aleksejs domā, ko darīt? Gribētu iesaistīt tiesu. Kuru tiesu? Latvijas, Baltkrievijas, kur pameklēt jurisdikcijas normas? Kā tad pēc tam izpildīs šo te, piemēram, Latvijas spriedumu Baltkrievijā vai otrādi Baltkrievijas spriedumu Latvijā? Un tad viņš paliek ļoti uzmanīgs, izlasot pirmos pantus Baltkrievijas tiesiskās palīdzības līgumā, redzot, ka tur ir vispārīga norma, kas noteic, ka vienas līgumslēdzējas valsts pilsoņi bauda tādu pašu savu tiesību aizsardzību, kā otras līgumslēdzēja valsts pilsoņi. Un mēs atrodam vārdu pilsoņiem. Tad viņš paliek ļoti aizdomīgs un domā, ko tad darīt ar šo te nepilsoņu statusu, vai līgums ir vai nav piemērojams. Patiesībā gribētu atstāt šo jautājumu atklātu. Un kāpēc atklāt? Tāpēc, ka tiesu praksē atbildi neesmu atradusi, papētīju, panelizēju diezgan daudz Latvijas tiesu nolēmumu, piemērojot šos tiesiskās sadarbības līgumus, bet konkrēti līdzīga veida jautājums nav bijis apskatīts. Mans, protams, redzējums uz to būtu tāds, ka šie līgumi ir ar plašāko aizsardzību un ar šo te pilsoņu domāts, iedzīvotāju kopums vai tie, kas dzīvo Latvijā vai Baltkrievijā, un lai nodrošinātu savu personisko mantisko tiesību aizsardzību, līgums būtu interpretējams paplašināti. Bet atkal šeit var strīdēties un diskutēt. Tas ir viens. Nākamais, varbūt jau drusku praktiskāks jautājums par valsts nodevu. Vai ir maksājuma valsts nodevai iesniedzot pieteikumu par ārvalstu tiesas nolēmumu atzīšanu un izpildi, kas pieņemta tiesiskās palīdzības līgumslēdzēju valstīs? Tātad Aleksejs tomēr izdomā, ka līgums ir piemērojams un sameklējot attiecīgās jurisdikcijas normas līgumā, izdomā celt prasību Baltkrievijā, bet pieļauju šajā te līgumsaistību jomā, līgumsaistību neizpildes jomā Baltkrievijā prasību nevarētu celt, bet tas atkarībā no apstākļiem, bet pieņemsim Aleksejs ceļu prasību Baltkrievijas tiesā, un ir apstiprinots spriedums, un tagad Aleksejs gribētu doties uz Latviju un atzīt šo te Baltkrievijas tiesas spriedumu. Rodas jautājumi, kā to Aleksejs pirmām kārtām dara un otrām kārtām, vai vispār maksājuma valsts nodeva. Šis jautājums nav galīgi izdomāts, šis jautājums ir no prakses, prasa praktizējušie juristi, prasa tiesneši. Un atkal risinājums viennozīmīgs nebūs, diemžēl jums arī nevaru dot vienu vai otru padomu, bet varu piedāvāt, divus variantus. Ja jūs sāksiet uzmanīgi studēt līgumu, jebkuru, pieņemsim to pašu ar Baltkrieviju, tad pie vispārīgiem noteikumiem būs ļoti interesanta tāda vispārīga frāze, ka tiesiskā palīdzība līgumslēdzēju valstu starpā notiek bezmaksas. Un tiesiskā palīdzība, protams, savā tostarp ietver arī sprieduma atzīšanas un izpildes jomu. Un piemērojot līgumu sprieduma atzīšanas un izpildes jomā, šī sadarbība notiek tā, ka ir Baltkrievijas tiesiskās palīdzības līgums, Baltkrievijas tātad tiesas spriedums. Šis tiesas spriedums caur centrālo iestāžu starpniecību, tās ir divu valstu tieslietu ministrijas, tātad Baltkrievijas tieslietu ministrija nosūta Latvijas tieslietu ministrijai, un Latvijas tieslietu ministrija tālāk pārsūta Latvijas kompetentai tiesai. Tātad šī sadarbība notiek pa konkrētiem posmiem, un tādā veidā tā tiek īstenota. Bet no otras puses, personai, tātad Aleksejam, nav liekta iespēja doties uz Latvijas tiesu, prasīt Baltkrievijas spriedumu atzīšanu, lai to izpildītu patiešo, nepiemērojot šo te sadarbības veidu, kas ir paredzēts līgumā, vai ne? Tāda opcija ir. Vai mēs pārkāpjam līgumu? Manuprāt, nē. Un tad rodas jautājums. Īstenojot tiesisko sadarbību, izmantojot šīs te iestādes, vai ir maksājuma valsts nodeva? Šķiet, ka nē. Ja Aleksejs tomēr dotos patieši uz Latvijas tiesu, tad šī valsts nodeva visticamāk būtu maksājuma. Bet, redzat, te ir dažāda interpretācija, un cik man zināms, vismaz papētot Latvijas tiesu praksi, tad, kad tiesiskās palīdzības lūgumi nonāk izmantojot centrālo iestāžu starpniecību, tātad tieslietu ministriju starpniecību, valsts nodeva netiek iekasēta par ārvalsts, tātad sprieduma atzīšanu izpildi, tātad tajās attiecībās, kur mums ir šīs līgumslēdzēja valstis, piemērojot tiesiskās palīdzības līgumus. Lūk, bet jautājums rodas pats par sevi, vai iekasēt vai nē, tad vai ir maksājuma vai nav maksājuma valsts nodeva. Nākamais, jau drusku sarežģītāks jautājums, bet varbūt visiem jau atkal viss ir skaidrs, tad mēs tikai veidojam kaut kādu kalamburu neizprotamu, bet tiešām atkal jautājums radies no praktiķiem, un par laimi savu nostāju var apstiprināt jau ar konkrētu tiesas lēmumu, bet drusku par pašu problēmu kā tādu. Tātad, ja kādā valstī ir konstatējošs fakts, respektīvi spriedums, pieņemsim, ka līgums tiek atzīts par spēkā neesošu. Un reāli izpildi kā tāda šim te līgumam nav nepieciešama Latvijā, bet šīs līgums vajadzīgs kā pierādījums, kāds prejudiciāls jautājums, kāda cita jautājuma, teiksim, izlemšanai Latvijas, piemēram, tiesās, starp tām pašām pusēm. Un vai šajā gadījumā ir nepieciešama atzīšana? Šī te ārvalstu tiesas spriedumā atzīšana Latvijā, kas pēc savas būtības neprasa izpildi. Es neprasu, pieņemsim, kaut ko man samaksāt. Es zinu, ka tas ir tikai un vienīgi konstatējošs spriedums. Un bija ļoti tāda mums savā starpā arī tieslietu ministrijā diskusija par to, ir vai nav. Jo, ja paskatāmies doktrīnu un papētam arī Latvijas civilprocesa likuma F daļu, ko mēs tur ieraugam? Mēs ieraugam to, ka runājam par sprieduma atzīšanu un izpildi. Tātad visi spriedumi, kas nāk, piemērojot F daļu, tātad civilprocesa likuma F daļu, viņi nonāk caur atzīšanas posmu, jebkurā gadījumā, vai tas būtu konstatējošs spriedums vai spriedums, kuram nepieciešama izpilde. Tajā pašā laikā, ja ņemam līguma tekstu, vienalga atkal kuru, kaut vai ar Krievijas federāciju, izlasam, ko mēs redzam. Ļoti vispārīga norma, un jautājums, kā to interpretēt, sašaurināt vai paplašināt. Un normā ir paredzēts, ka tādi lēmumi vai spriedumi, kas ir saistīti ar aizgādības, aizbildnības tiesību jautājumiem, ar civilu stāvokļa aktu jautājumiem vai jautājumiem, kas pēc savas būtības neprasa izpildi, netiek pakļauti atzīšanas procedūrai. Lūk. Šķiet, norma ir ļoti vispārīga un patiesībā izlasot diezgan skaidra. Tātad šāds te Baltkrievijas vai Krievijas spriedums, kas ir tikai konstatē faktu, un ja mēs gribam viņu izmantot kā pierādījumu Latvijā, nav nepieciešams atzīšanai. Tātad šim te spriedumam nav nepieciešama atzīšana. Tajā pašā laikā mēs esam mācīti universitātēs, mēs lasam doktrīnu un saprotam, ka šī te atzīšana, kā suverenitātes izpausmes, teiksim, princips ir nepieciešams, jo kāpēc tā atzīšana kā tāda ir? Jo mēs runājam pārsvarā par atbildētāja tiesību dubulto kontroli šīs te atzīšanas valstī, šajā te izpildes valstī. Tātad mēs vēlreiz pārbaudām, vai sprieduma izcelsmes valsts tiesa ir ievērojusi atbildētāja tiesību aizsardzību, un tas ir viens no principiem, kāpēc šī te otra pārbauda, otra kontrole nepieciešama. Lūk, tāds ir bijis jautājums, par ko ilgi diskutējam, jo savā starpā nonāca doktrīna un arī konkrēts līguma noteikums. Tātad vienalga, jebkura tiesiskās palīdzības līguma noteikums. Un tagad rakstu gatavojoties arī konferencei, uz to brīdi nebija pieejams spriedums, piedošanu lēmums, bet tagad es jums varu painformēt, tad tas ir 2012. gada 14. augusta lēmums Rīgas apgabala tiesas civilietu tiesu kolēģijas. Gribētu nedaudz arī ieskicēt nosaukumu, tātad Kipras komercsabiedrības Broda Agro Trade Limited pilnvarotā pārstāvjā zvērināta advokāta Erlene Kalniņa par blakus sūdzību saistībā ar Rīgas rajona tiesas tiesnesa 12. gada 11. jūnijā lēmumu. Un tur kā reiz arī bija šīs te jautājums. Vai ir vai nav jāatzīst? Konkrēti bija Krievijas viena apgabalā tiesas sprieduma atzīšanu šeit Latvijā. Tātad vai ir vai nav jāatzīst šis te Krievijas spriedums, jo šis spriedums pēc savas būtības Latvijā neprasīja izpildi, bet bija vienkārši ar konstatējošu raksturu. Tātad konstatēja kaut kādu konkrētu faktu. Un rezultātā Rīgas apgabala tiesa nonāca pie secinājuma, ka šādiem spriedumiem, kuri neprasa pēc savas būtības izpildi, atzīšanas procedūra Latvijā nav nepieciešama, piemērojot tiesiskās palīdzības līgumus. Nevaru jums pastāstīt, vai apelācija pārsūdzēts vai nav pārsūdzēts šis Rīgas apgabala tiesas lēmums, bet jebkurā gadījumā, ja nav pārsūdzēts, tad turpmāk visticamāk šī būs pirmā tāda lieta, uz kuru varēs arī atsaukties praktizējošie juristi un arī mēs ministrijā, pamatojot, kāpēc, piemērojot tiesiskās palīdzības līgumus, šī atzīšana konstatējošiem spriedumiem nav nepieciešama. Bet jāsaka, ir bijusi ļoti liela diskusija šajā jautājumā. Pats pēdējais, kā piemērs, arī problēmas atspoguļošanai un arī nedaudz ieskicēts risinājums saistībā ar dokumentu legalizēšanu. Tas vien praktikiem ļoti svarīgs jautājums, un tāpēc es tā vēršu jūsu uzmanību savā runā tikai uz šiem te praktiskiem jautājumiem. Respektīvi, vai ir nepieciešams legalizēt dokumentus, kas tiek sagatavoti šo līgumslēdzēju valstu tiesās, vai kuru sagatavo oficiālas personas, bet kuru iesniedz citai līgumslēdzēju valstī, vienalga kaut vai uzņēmuma reģistrā, vai civilstāvokļu aktu jautājumos un tā tālāk. Vai šiem te dokumentiem ir nepieciešama legalizācija? Un kāpēc šis jautājums pēkšņi palika svarīgs? Tāpēc, ka Latvijas iestādes patiesībā šo jautājumu skatījās ļoti liberāli, un, ja mums pretī ir kāda Igaunijas notāra dokuments vai Lietuvas notāra dokuments, viņi ņēma pretī, neprasot legalizāciju. Tātad ņēma parakstītus dokumentus, tulkotus, ja nepieciešams, un nekāda problēma nav bijis. Bet problēma pacēlās citās valstīs, līgumslēdzēju valstīs. Mūsu pilsoņiem, mūsu iedzīvotājiem, teiksim tā, sāka prasīt, lūdzu, legalizējiet Latvijas notāru dokumentu. Ja gribat viņu kaut kur iesniegt tajā valstī, kaut vai vienkārši parādīt, ka tur ir vienošanās noslēgta, piemēram, pie notāra. Un tagad mums jautā atkal, tā pašai tieslietu ministrija jautā, kā tā ir? Kā tā ir ar tiem līgumiem, īstenojot šo te savstarpēju tiesisko sadarbību, vai tāda prasība tiešām nepieciešama? Jo personas negāja šo te ceļu, caur centrālajiem iestādēm nemēģināja iesniegt šos te dokumentus, bet vienkārši patiešām aiziet uz iestādi un iesniedz un palūdz, lūdzu, paņemat šos dokumentus pretī. Neņem pretī, lika legalizēt. Un atkal legalizācija, daudz zinām, ka tā ir atkal gara tāda procedūra un laiks un arī finanses nepieciešams, lai to procedūru izietu. Lūk. Rezultātā patiesībā šī problēma pirmām kārtām bija pacelta Baltijas valstīs, Latvija, Lietuva, Igaunija. Sanāca valstu pārstāvji un rezultātā izdomāja novienoties savā starpā, bet šī vienošanās ir deklarācijas veidā. Tie nav nekādi papildinājumi tiesiskās palīdzības līgumā ar Igauniju un Lietuvu. Novienojas, ka tomēr ļausim šo te paplašināto interpretāciju un ļausim mūsu iedzīvotājiem šajās te valstīs iesniegt dokumentus patiešo bez legalizācijas prasības. Bet atkal tā ir deklarācija un apusēja vienošanās. Tiesām ir izsūtīti, visām iestādēm ir izsūtīti tādi apkārtraksti, lūdzu ievērot un neprasat šo te legalizācijas prasību. Jautājums paliek atklāts jebkurā gadījumā uz citām valstīm, uz to pašu Krieviju, uz to pašu Baltkrieviju, kā notiek tur. Un vai šī interpretācija, kas mums ir pieņemama Latvijā attiecībā uz Igauniju un Lietuvu, darbosies šajās te citās līgumslēdzēju valstīs. Nu, lūk, tas ir tik daudz par praktiskiem jautājumiem, kas saistīti ar vienveidīgas interpretācijas jautājumiem. Nākamais, tā kā plūstoši pārējot, zinu pavisam nedaudz, Eiropas Savienības jautājums un Eiropas Savienības prasības. Jūs noteikti varēsiet jautāt, labi, ir Eiropas Savienība, bet mums ir ārējā dimensija, mēs iztenojam savu valsts vēlmi piemērot tiesiskās palīdzības līgumus, kāpēc, lai rastos problēmas, kāpēc, lai vajadzētu kaut ko tagad domāt un vispār šo jautājumu cilāt. Nav tik vienkārši. Eiropas Savienība īsteno arī ārējo tiesību politiku, un arī Eiropas Savienība ir teikšana šajā jomā. Tātad līguma par Eiropas Savienības darbību 351. pants. Visi tie līgumi, kas noslēgti ar trešajām valstīm, ir pārskatāmi, lai nodrošinātu atbilstību Eiropas Savienības prasībām. Ļoti vispārīgs pants, bet uz tā panta bāzes veidojās tālāk jautājums, ko darīt un ko tas nozīmē. Līgumi ir noslēgti 90. gadu sākumā, un vai tad tagad mums būtu kaut kas ar tiem jādara? Un rezultātā atbilde ir jā, jādara, jo tālāk jau seko nākamās Eiropas Savienības regulas, konkrēti atrunājot, kā valstis un par kādiem jautājumiem drīkst pārslēgt līgumus ar trešajām valstīm. Un, piemēram, jums ir gribēsiet papētīt viena regula 662/2009, bet ar ļoti šauru piemērošanas jomu un saistīt ar to, kā nodrošināt līgumu pārslēgšanu jomā, kas saistīta ar piemērojumā likuma jautājumiem, līguma saistību un ārpuslīgumisko saistību jomā. Tātad ļoti šaurs jautājumu loku. Līguma saistības, ārpuslīgumiskās saistības, bet tikai un vienīgi piemērojamais likums. Ne jurisdikcijas normas, ne sprieduma atzīšanas un izpildes normas. Nākamā gan regula ir daudz plašāka, kas ir saistīta ar ģimenes tiesību jautājumiem, aptverot, kā pārskatīt valstīm tiesiskās palīdzības tātad līgumus ar trešajām valstīm, kuri ir saistīti ar jurisdikciju, sprieduma atzīšanu un izpildi, piemērojamo likumu ģimenes tiesību jomā. Tātad zaļa gaisma ir dota, un ar to ir par maz, ir doti arī termiņi. Un termiņi ir 2017. gada vidus. Tātad šobrīd Tieslietu ministrijā uzsākusi darbu pie tiesiskās palīdzības līguma pārslēgšanas, lai šie līgumi atbilstu Eiropas Savienības prasībām. Tajā pašā laikā es neteiktu, ka situācija ir tik skaista un rožaina. Mēs redzam, mums ir regulas, kas mums atļauj pārslēgt, kas mums atļauj noteiktos tiesību jautājumos analizēt un pārskatīt tiesiskās palīdzības līgumus, bet tajā pašā laikā neaizmirstam, ka mums ir pretī lielas valstis, kas ir Krievijas federācija, kas ir Ukraina arī dzēn, kas ir Baltkrievija. Un jautājums, viens ir Latvijas vēlme pārslēgt, nodrošinot šo te balansu, teiksim, ar Eiropas Savienības tiesībām, bet pretī mums ir lielas valstis, kuras var pateikt, nē, mums apmierina esošais regulējums, un, teiksim, varbūt jūs mums piedāvāsiet, un kaut viens no regulējumiem tomēr kaut kādā veidā ierobežos mūsu pilsoņiem tiesības, varbūt kādā vai citādā gadījumā izvēlēties kādu, pieņemsim, tiesu vai piemērot kādu likumu, kas, teiksim, vairs nebūs atbilstošs viņu interesēm. Un rezultāts ir tāds, ka, tas ir, es teiktu, tas ir koks ar kādu iespējamo risinājumu, jo piedāvāt var rakstīt līguma normas, draftēt jaunas, skaņot ar komisiju, bet pretī būs, un tad rodas nākamais jautājums. Ja kāda valsts saka nē, vai mēs, Latvija, būsim izpildījuši savu saistību pret Eiropas Savienību vai nē? Lūk, uz šī tāda atklāta jautājuma es laikam gribu jums pateikt paldies par uzmanību un varbūt arī tiksimies diskusijās, ja? Paldies!
Paldies! Thank you very much for this interesting presentation. Now, audience, that's your time. We are looking forward for the questions, commentaries. I saw Professor Torgans wants to say something. Baiba has written some commentaries. So I would encourage you to be active and especially use that there is foreign experts here in this conference. So any comments, any questions? Or while you are, yeah.
I'd like to ask a question to Ms. Kemalādze about what you said about public policy. You said that state courts in Georgia interpret this notion very widely and freely. So my question is whether there is a body of jurisprudence which was adopted before this new law, and which might be, and which probably should be, binding to the state courts in interpreting this public policy notion, because it is common that this notion is usually made to restrict the courts, and the courts restrict themselves by this notion by saying that it should be interpreted very narrowly.
Thank you very much. As I said, the previous law on arbitration did not envision any recognition or enforcement procedure. So there was no notion of public policy in the old law. There was this concept of changing of the words, and the courts were changing the words. But what is interesting is that Supreme Court of Georgia, even when the old law was in place, at that point of time issued an opinion whereby it encouraged all the courts to, when revising arbitration awards, not to go into the merits of the dispute, but rather to address only procedural injustices. So, and that was when the old law was in place. Now we have the new law, which is based on the model and which provides for this clear grounds for challenge and for recognition and enforcement. So I wish that they would comply with the old recommendation of the Supreme Court, because the problem is not just in the fact that they invalidate those. I mean, the end result of fairness may be there, but the way they do it really creates a problem in all a problem, because there's no analysis, there are no guidelines why that is a public policy, and just saying that because it violates law of obligations opens really door that in all other cases it can be used, the public policy can be used as a way to revise awards. So that is, that is the problem I see in the current, in the way courts interpret currently public policy.
Perhaps if you could elaborate about this public policy, I wonder if there doesn't exist already a jurisprudence on this public policy notion. Have the courts of Georgia already interpreted this, for example, in other cases, not concerning arbitration, but concerning, for example, the recognition of foreign judgments? What I'm interested in is whether there is already, whether you, any lawyer in Georgia, understands what this public policy notion means in Georgia, because every state has its own interpretation.
Yes, that is true. I'm not aware of the notion of public policy in the sphere outside of arbitration. The way it has been interpreted within arbitration, they have considered public policy in other occasions as well, like when there were procedural irregularities, when there was a conflict of interest, and those were more narrow and correct applications. But at the same time, we have this line of decisions which say that, well, because the courts would apply the law differently, and because they consider reasonable a different amount of interest rates, they find it against the public policy of Georgia because it's against the main principles of the law of obligations. That is something dangerous, I think. Yeah.
Thank you.
Thank you. Well, I would like to use my capacity and ask the question to Domenico. The Latvian legal community is kind of looking for the medicine, how to cure the arbitration. One is to draft the new arbitration law or amend the civil procedure law that corresponds to model law. However, the biggest problem, I think, is a notion about so many arbitral institutions here in Latvia, but we see this trend also in Georgia, in Russia, for example, better Russia. So what would be your advice? Shall we kind of fight with this big number of arbitrations, like just start from the ground zero and we will have only one arbitration institution? Should we forget about those 200 and dismiss them? Or we still have to give a priority of the party autonomy if they agree to the arbitral institution, one of those 200 arbitral institutions. So what is a cure for us? So what would you suggest how we should react on this number of arbitral institutions?
Well, that is a very interesting question because you know that arbitration is based on the principle of party autonomy that you mentioned before. But then when you look at the reality of practice, you see that in most countries, at least as far as international arbitration is concerned, you really have one, maximum two arbitral institutions. In most countries, it's like that. So whether the situation was attained as a matter of market selection or not is a different issue. To me, it's a matter of market selection because in other countries, England, Italy, Sweden, in most countries, especially European countries, you have one. Now, to be honest, I'm a bit surprised that after a few years now, in Latvia, you still have these very many.
And it's increasing.
It's increasing. So it is really a case study to me, but I would like to really understand whether when it comes to at least international arbitration, how many of them are really active. Because one thing is having them on paper and then perhaps they have 1 or 2 cases per year. Or one thing is, look, perhaps if you ask me, really a straightforward piece of advice, I would say I would combine the two issues. I would say market selection, but some degree of control. The degree of control I would tentatively introduce in the market would be that international cases can only be dealt with by certain institutions with certain characteristics, i.e. track record, i.e. a structured institution, or a set of rules which has been somehow approved by a board of experts in Latvia, and you may be one of them, of course. And I would introduce that, especially because when you assure a degree of quality of service, then you would even inevitably attract cases into Latvia, and that would somehow shape the Latvian environment considerably. So my gut reaction would be just leave it to the market, but regulate, at least when it comes to international, and then would be a first step towards some degree of selection of institutions.
Mm-hmm. Thank you. Any other comments? Professor Torgan, varbūt jūs kaut ko gribat? Yes, Alexei.
Raiņa, obviously. Then after being cited so much, I have to ask something. and actually, you hit the spot with your example, because actually now I have a case when, fortunately not me, but my client has presumably borrowed some money from a Polish citizen. And when he presumably has not returned it back, the Polish citizen filed a claim in Belarus, and he lost it. The court decided finally that the agreement was actually fake. So it's a forged agreement. The Polish citizen has not obviously stopped and started the criminal case in Poland, trying to argue that the Belarusian is cheated. So now we have a situation that we have a Belarusian judgment in force, and we have a potential criminal case in Poland. And I understand there is, apart from the EU legislation, you have a treaty. I understood you have a treaty with Poland. My question is, have you touched in your research the issue of the potential conflict between the two different treaties, the treaty and the EU legislation, and the treaty and, for example, New York Convention? Because I personally know from a different case that I also had that actually in Latvia it was decided in one case by the Supreme Court the potential conflict, existing conflict between the arbitration award rendered in Russia against also the Supreme Commercial Court decision rendered in Belarus. So again, if you may have...
You want Irena to solve your case, right?
Thank you for your question. Actually, I have to say that, first of all, sorry for mentioning you. But by answering to your question, actually the first step would be that we will take EU legislation in order to see how it harmonize or not harmonize the idea what we are going to get into the treaties by new provisions. But yes, it's because of supremacy, because we have this obligation to look into the regulation, for example, Brussels I on recognition and enforcement and jurisdiction in civil and commercial matters, because we have the same topic in treaty of legal assistance or mutual legal assistance. So, other question is applicable law to contractual, non-contractual obligation, family matters in cross-border matter, in a cross-border aspect, but. As for now, we are deciding to divide, but only deciding, it's an idea that we can divide or split our treaties into two parties. That one would be on civil matters, on cross-border civil matter, and the other one could be on criminal matters. And I am not responsible for that one, therefore I can't say what could be on what is the best solution in your case. But anyway, first of all, we will look at the EU law, and afterwards we have to decide on our motion whether we want to have one kind of provision or not, but it should be looked into. Yeah, thanks.
Thank you. Any other observations, commentaries?
I'd like to ask another question to Mr. Anichenko. Yes, you mentioned that during the adoption process of legal acts in Belarus, also the president's office and the state control agency takes part. I'm interested, what is their role in this process? Is it merely supervision, or do they also actively take part in the contents? Do they add to the content of those legal acts?
Actually, they are quite active, and that is in the first place, the procedure is quite kind of extensively defined in the law, on the legal acts that we have, and some procedural instructions. But again, the issue here is that because, for example, the Committee of State Control is usually with the most of the kind of really important acts is supposed then to control the application. So they are quite active on the drafting phase, because they actually, as practice shows, usually very experienced in the particular area. For example, give the environment protection or taxation or customs. They are usually quite strong professionals, so, and their input is actually usually very valuable, sometimes controversial, but still they are dealing with the laws afterwards. And presidential administration is a bit different thing, because again they are responsible to the president that everything he signs is actually in line with the generally with the policy, with the kind of strategy which is being chosen. So they are more reserved in a sense, but they are like before the bill goes to the parliament, they are saying their kind of last words. So they may return the law back to the drafters, and basically with the law of mediation, it was exactly the presidential administration who was every time returning back to the Supreme Commercial Courts for further development. But now, again, but on the other hand, now we are more or less sure that it will be approved and signed by the president by the end of this year.
Thank you. So, any other last question, commentary? Use this possibility.
If I may, I have a question for Professor Di Petrio. And in your speech, you were sort of emphasizing the transparency requirement and obligation of transparency in arbitration proceedings, and as one of the core elements being the arbitrators guaranteeing the independence and impartiality. But I was wondering, what are your thoughts on the shifting of burden of proof, which might exist in certain cases, whether the arbitrator is independent and impartial, for instance, due to the growing, let's say, technology trends, and how has the burden of proof, the weight of it, shifted with the development in the technology? Because what I have heard, that even being friends on Facebook might give certain doubts about independence and impartiality in certain cases. And the other question to the same subject is, what do you think, to what level should actually the state be involved in ensuring this certain component of arbitration? To what extent should the state be involved in ensuring that this criteria is fully observed by the arbitrators? Because on the other hand, it's still the party's autonomy, so should the state actively interfere in controlling whether the independence and impartiality criteria is observed in arbitration, or should the state just leave it to the parties? So it may be quite complex, but I would love to hear your opinion on this.
Well, it's a wonderful question, because it is exactly what has been going on in the last few years. And there has been a huge increase in terms of awareness of the duty to disclose, because we are moving to, as I said before, to a stage where arbitration is heavily used, even in matters that are not just merely private. Now, it is no longer accepted that in doubt an arbitrator may be allowed not to disclose, because each one of us will feel perfectly placed to decide a dispute, even if there might be an element of connection with one of the parties. I'm sure that deep inside we think genuinely, I can exercise independent judgment. But it's not so much important what we think, it's what is important what other parties think and how they perceive our role in the arbitration. I can think I'm perfectly independent, but in fact I might not be, because unconsciously I might go for one of the parties. And what is important was the system sees. And this is why before I mentioned the justice is seen to be done. It's not just what within the realm of an arbitration, the closed space of an arbitration, what we do. Now, this is why all institutions are moving towards disclosure in doubt. This is what the ICC has done. There is an express statement of independence and impartiality, and they say, in doubt, you disclose. This is what ICSID has done since 2006. Now the general rule is that. Your first question was, I'm concerned because now there is a very fast way of connecting people, and that connection is publicly available. Because I might be connected on Facebook, I'm connected to many practitioners on LinkedIn, for example.
I know some.
So the thing is that enough to show that I'm not independent or impartial? There is an element of risk. Because a desperate party might say, oh, you have been linked on LinkedIn, on Facebook, how come? Is there anything else? Now, what I would do, I would disclose anything in my statement. But then, of course, when does it stop? Because once an arbitrator has been challenged because of have participated in the publication of a book together with someone else, and that is, to me, is not enough. But that is a risk that you run. You also run the risk if you issue spurious challenges that vis-à-vis the arbitral tribunal and the institution, you lose any credibility. This is why the institution will be very, very strict. There is always an element of risk. And there is an element of risk, I can tell you, and this is, a war story. Do we have time?
Sure.
1 minute. An arbitrator did not disclose that his firm had done work in the past for the party that appointed him. There was no longer anything in their website. The other party ran, since you mentioned technology, I did not know that it was something like this, a Google cache thing, when you actually see web pages that are no longer online but used to be online, and it's like a photograph of that page. You go to Google cache and you see the old website, how it appeared. And in Google cache, someone found that firm advised the party that appointed one of the lawyers in the arbitration, so there was an issue. The other question that you asked, if you could remind me of that, was...
It's more focused on to what level should the state or the control institution involve.
It's very topical what we discussed today. Should it be left to the parties? Well, the parties and the institutions are in charge. What is coming out is that they can do whatever they like, they have complete control of the proceedings, but they should bear in mind that there is a limitation, there is a limit to that freedom, because you always have to come to terms with the mandatory provisions of the place of arbitration. Let's leave it in, say, investment arbitration aside, and in ICSID it's a different word. But if we look at, say, 95% of international arbitration is commercial arbitration. You can believe that you are free to do whatever you like, but you are not. And you are only free to run your arbitration within the boundaries of what the mandatory provisions of the place of arbitration will let you do. And you also have to remember that then that arbitral award may have to be enforced somewhere else. And so you have to bear in mind the public policy rules of the place where enforcement is expected to be sought. So yes, you can do whatever you like, but when it comes to enforcement, when you run to the courts to ask for assistance, they will, check whether you use your freedom meaningfully.
Thank you very much. So our time is over. So I would like to thank distinguished speakers. I would like to thank you, audience. I would like to thank faculty staff for helping us. And of course, big thanks to interpreters. Thank you very much.